My name is Louise Kelso, and I'm a partner in the professional risk team here at Brodie's, or today in my front room, as many of you will be. Thank you very much for dialling into our session today on delivering professional services during COVID-19. I'm joined today not by Elena Fry, who was previously billed as a speaker, but is unable to join us today, unfortunately. But instead, we have another of our experts in health and safety, Victoria Anderson. She's a senior associate in our insurance and risk team, and she's been advising clients on the many health and safety issues arising during the current situation. It's really worthwhile having Victoria here today because, of course, health and safety is moving up the agenda very quickly for professional services practices, given that the majority of professionals are working from home and indeed now are becoming long-term home workers, and we'll discuss what that means later on in the session. So by way of introduction, I thought I'd open just with a few shots of the modern workplace for professional advisors. And I think you'll agree those pictures are very different to what we were used to in terms of workplaces. I couldn't find readily any images of home offices being overrun by small people or workers having bad hair days, but I'm sure there are lots of those out there. As lawyers, we've had some guidance from judges across the pond in the US about what's acceptable on a video call, and those judges have suggested that appearing in court virtually without a shirt on or from underneath a duvet just isn't acceptable. So some guidance for all professionals there, I think, as to how to behave on a video call. For many professionals, can we just go back to the introduction slide, please, Dominic? Thanks. For many professionals, the primary task has really just been trying to keep operating during the restrictions and while moving large numbers of workers from the office to home working. The purpose of today's session, however, is really to highlight that risk management has probably never been more important for professionals and professional practices. And that's because there is a really rigid dichotomy between the number of complaints or claims that we see against professionals and the performance of the economy. So in other words, when times are hard, there tends to be an uptick in claims and complaints against professionals as those feeling the pinch try to recoup any losses wherever possible. The perceived deep pockets of those professionals and their insurers become a target, frankly. Take, for instance, the significant spike that we saw in those types of claims, particularly against surveyors and lawyers following the crash in the residential housing market. So we can probably expect that the many financial pressures arising as a result of COVID-19 could well give way to an increase in claims, complaints and reputational issues for professionals. So turning to the overview of today's session, let's have a look at what we're going to speak about. So on the slide there, we've set out that firstly we'll be looking at some of the trends and triggers for complaints against professional service providers. So what did these claims look like before COVID-19 and what best practices could be adopted to avoid these sorts of issues arising. Then we'll look at the impact that COVID-19 has had and the additional risks that are arising from the current restrictions and, of course, their hopefully impending relaxation in Scotland. Then Victoria will talk us through the health and safety issues for home workers, providing a summary of the applicable law relevant to the risks arising from COVID-19 and as some of the restrictions are lifted in going back to work premises. And then finally, we'll have a look at some practical pointers on dealing with formal complaints or claims and reputational issues. So before we delve into all of the challenges of delivering professional services, it's worth just talking about what we mean when we're discussing professionals and professional services. Well, there are lots of different definitions that can be used for the term professional, depending, of course, on the context and circumstances. There are those traditional professions, which everyone would recognise as falling within the definition for professionals, such as doctors, accountants, architects, engineers, and so on, and all of those regulated professionals who have to meet specific standards and where compliance is usually monitored by industry bodies. But in reality, of course, the definition is much, much broader. There are lots of modern and emerging professions, as they're sometimes referred to, across a broad range of sectors, from energy to media and beyond. The other way of looking at what a professional might be is to think about who needs professional indemnity insurance. And I've listed on the slide the types of issues that typically can give rise to claims under a professional indemnity policy. Perhaps most commonly, professionals are those people who can and do face claims of negligence. So failures to deliver professional services, breaches of professional obligations, and those include fiduciary duties, so duties of trust and confidence. The list goes on. There at the foot of the slide, there are some other key issues which we're advising professional practice clients on in light of COVID-19, but which are not typically covered by professional indemnity cover. We'll touch on some of those in more detail later on, of course, but it's certainly not an exhaustive list given all of the new challenges which have been emerging on a daily basis. So turning to some of the current trends, or at least the pre-COVID-19 trends, everyone makes mistakes from time to time, unfortunately, but what are the typical causes of complaints, claims, and reputational issues for professionals? Well, here we have some of the main triggers that we see in our day-to-day work, and it may surprise you to know that in some sectors, poor communication features in at least 25% of all claims or complaints. That poor communication is often the trigger in the root cause or plays some part. So looking at the top row there, for example, where there are the issues of work not being done or unrealistic expectations, in my experience, these really are usually about communication issues, perhaps where the agreed scope of work wasn't clearly set out at the start of the job, or the client or professional has lost sight of that along the way, resulting in the dreaded mission creep, whether actual or perceived, and perhaps through expectations not having been managed as a job progresses. There on the second row, again, we have some communication issues, the soft skills that can sometimes fall by the wayside with the pressures of delivering professional service. And then at the bottom, some of the types of technical issues that we do see. You'll be surprised to hear perhaps that, yes, mistakes are made and delays happen, but cases of gross negligence are not really as common as you might think. And it's worth saying finally that cost is seldom the primary issue in a complaint or claim, or at least not in those cases that make their way to insurers, to lawyers, or to the courts, but cost nearly always becomes part of the picture when an issue is raised by a client or customer of a professional. Another trend, which is perhaps a more interesting one, is the blurring of lines between the professional and private lives of those providing professional services. So we're seeing professional regulators as a rule becoming far more willing to scrutinise the behaviour of professionals in their private lives and out with the workplace, resulting in varying degrees of penalties where that behaviour is perceived to have fallen below the standard expected of that professional, from fines or censures to restrictions on practising or even striking off and that type of thing. I've included on the slide there a few recent headlines as to the types of behaviour that have been examined by professions and their regulators, and some of those are just, you'll see from the dates there, towards the end of last year and the beginning of this year, so it's very recent. Fortunately, of course, in present circumstances, there is much less opportunity to engage in any behaviour that might bring a profession into disrepute, or at least much less opportunity to do so publicly, as we're not allowed to go anywhere. But professionals do need to bear this particular trend in mind, and I'd suggest particularly when the measures are relaxed and celebrations start to begin, bearing in mind those obligations to behave in our private lives as well as public lives is really important. How then has COVID-19 impacted on the law affecting professionals and how they practice? Well, although regulations have come into force requiring the closure of certain businesses and premises, as I'm sure you're all aware, those really relate to the leisure and retail sectors most of all. Professionals are affected, however, by the stay-at-home rule, which until this week applied throughout the UK to everyone unless they were armed with a reasonable excuse. And of course, as you'll know, that included going to work, but only where that work cannot reasonably be done from home. And of course, for many professionals, their services can be delivered in that way. The regulations in Scotland also require from the 21st of April that all businesses take reasonable steps to implement social distancing, and it's an offence not to comply with that requirement. There are also no exceptions to the social distancing rules, not even for businesses that are critical to lives and safety. So it's something that's really high up the agenda for all organisations, and rightly so. Then in addition to the regulations, we have government guidance, which the guidance has no direct legal effect, but acting contrary to it could of course have reputational and political consequences, it's safe to say. In Scotland, the government guidance provides certain criteria for businesses that may remain open. For example, that it's essential to the health and welfare of the country, or it's supporting essential services. There are 13 critical national infrastructure sectors which help businesses to define whether their facilities, systems, sites, networks are necessary for the functioning of the country and the delivery of essential services. And those are services that underpin daily life and ensure that the country continues to function. But even businesses operating in those sectors can only maintain premises or on-site functions which are critical. So as you can see, some professionals may be able to demonstrate a need to maintain and operate their premises, but it's a very, very high bar that businesses have to meet in order to justify a decision to remain open. It really has to be considered on a case-by-case basis. Of course, the Scottish Government guidance differs from the UK Government guidance, and the Scottish guidance has, in general terms, been much stricter throughout this whole period. We're of course already seeing the relaxation of the measures differ too, as set out by the Prime Minister and the First Minister in the last few days, and the guidance that has followed for the UK rather than Scotland. So professionals doing business across the UK will need to bear in mind, of course, that customers and clients may have different expectations. The key takeaway for professionals and professional practice firms is that whether or not the guidance allows operation of premises to any degree, there has been no general relaxation of professional, contractual or legal obligations. So those duties that were owed by professionals to their clients and their regulators continue, irrespective of COVID-19, and any failure to meet those obligations may not be excused by the current situation. As so many professional practices have successfully moved and adapted to home working, it simply can't be assumed that any failure to deliver professional services to the appropriate standard due to the present circumstances might be forgiven. So looking at some best practice then, the usual rules apply for minimising the risk of complaints and claims. At its most basic, that means ensuring that usual service and standards are adhered to wherever possible. I mentioned early on that poor communication is a significant contributing factor to claims and complaints in any circumstances, so ensuring good communication is key, both within an organisation and with clients, customers and third parties, or anyone that you might be dealing with externally. The importance of record keeping just can't be underestimated, and often a professional advisor will be adamant that certain advice or warnings were given, but there's just no evidence of it within their file or their notes. While everyone is working at home, of course, there's a much, much greater risk that this kind of evidence might be lost as people jot things down in notebooks and put them in a drawer. We'll have to rely upon, in those circumstances, what a professional can remember about what happened or what their usual practice might have been if those notes go missing. So reminding workers about the importance of keeping good records somewhere that they can be accessed by the business could be absolutely key to defending claims or complaints later on. It would also be worth revisiting the terms of any current contracts, including standard terms and conditions, which might look at, for example, where or how work is to be done, and that may have changed in light of the current situation. And in terms of limits of liability, an amendment might be needed to exclude liabilities that arise if, for example, a third-party service provider is unable to fulfil their usual role due to COVID-19. For example, difficulties experienced by HMRC, the planning authorities, contractors, those sorts of parties. Proactively managing deadlines is also advisable so that additional time can be built into processes, because some professional practices are finding that even sending a letter is taking a bit longer than usual. On that note, practices really need to identify any increased risks and carry out risk assessments where necessary. For example, everyone will have heard about fraudsters looking to capitalise on the current situation for those businesses who are now doing all of their banking remotely. And clearly there is a significant body of work to do in ensuring that employees are properly supported with adequate supervision and training, which Victoria will come on to discuss in a moment. Finally, considering whether there is any relevant insurance cover in place for any of these issues is worthwhile. And on that note, of course, everyone is talking about the topic of my next slide, which is business interruption. Now, business interruption is a session in itself, so I'm not going to try and cover it in detail today, but here are some key points just to consider. Firstly, this type of cover is usually for loss of profits and designed to kick in where there has been some physical damage to premises. It really, I think it's safe to usually apply to COVID-19 in that context, but wording varies. Whilst some policies will have cover for infectious diseases or pandemics, they may be defined by a closed list, and that list may refer to coronavirus but may not include COVID-19. So looking at the wording is really important. The other possibility, of course, is that cover may be engaged where there's been a government order to close premises, but the general view, as expressed by the Association of British Insurers, is that the vast majority of policies will not respond. If you're in any doubt, then do speak to your broker, your insurer, your lawyer. Let's turn then to look at some of the health and safety aspects, and I'm absolutely delighted to have Victoria here today to look at this issue, which, as I've said, is moving firmly up the agenda for office-based businesses. Victoria, over to you.
Thanks, Louise. Starting at slide 11, the first thing to understand is that UK health and safety laws have not changed or been relaxed as a consequence of COVID-19. I've put a quote on the slide there, which was lifted from the HSE's website, confirming the position. So, and by way of reminder, all employers have a duty to ensure, so far as is reasonably practicable, the health and safety of employees and members of public affected by their business activity. That is the overarching obligation which is set out in the Health and Safety at Work Act 1974. There is a lot of other more specific legislation that sits alongside that, and breaches can result in criminal action being taken against a business, including prosecution. I would also highlight that there is no need for an actual injury or incident to have occurred. Simply by creating the risk of injury or incident, then the law has been breached. And I'd also stress that individuals as well as companies can be prosecuted and potentially imprisoned if convicted. Similarly, in the civil liability context, the obligation is to take reasonable care for the safety of employees and members of the public. It's a common law obligation, although in assessing a relevant standard of care, a court will generally consider if a business has complied with health and safety law, and a breach of the common law obligation to take reasonable care will give rise to damages if there is a loss or injury. So health and safety law plays a very integral part in all of this. How then does COVID-19 fold into that existing health and safety regime? Well, the risks arising from contracting COVID-19 are so well known that, simply put, employers have a duty to ensure, so far as reasonably practicable, that employees and members of the public, and that includes customers, business professionals and any contractors, that they don't contract COVID-19 as a consequence of the employer's business activity. Failing to so ensure could give rise to enforcement or prosecution under the existing health and safety regime, as well as the coronavirus regulations, and give rise to civil damages claims. Turning then to my next slide. How as a business do you deal with all of this? Well, most professional services businesses are what I would normally call low health and safety risk environments. But COVID-19 brings a new risk to all businesses that has to be actively managed. This means pausing and reviewing existing risk assessments, carrying out new risk assessments and factoring in the hazards arising from COVID-19 to all of your business activities. And just to be clear, all employers have a legal duty under the Management of Health and Safety at Work regulations to make a suitable and sufficient assessment of the risks to the health and safety of your employees that they're exposed to whilst at work, and also the risks to the health and safety of persons not in your employment, but who might be affected by your business activity. I'm going to turn now to cover off two broad areas here which generally apply to professional service providers. That is those working from home and returning to the office. On my next slide, we've got home workers in the left column and the returning to work options as well. So this is, I think, our 8th week of lockdown, and during that time many former office-based professionals have been working from home. Initially, such people would have been classed as temporary home workers, but the longer working from home continues, the more likelihood there is that people will move into the long-term home working category. Employers have obligations to manage risks arising from working from home in the same way that they do assessing risk at the workplace, such as working from height, for example. So what are the risks arising from long-term home working? Well, the Health and Safety Executive has some very useful material on this on their website. When somebody is working from home permanently or temporarily, the employer should consider the following. How can you keep in touch with your staff? What work activity will they be doing, and for how long will they be doing each task? Can the tasks be done safely? And do you need to put control measures in place to protect your staff? There are specific things to consider when addressing this, which include lone working considerations. There are greater risks for lone workers with no direct supervision or anyone to help them if things go wrong. So the Health and Safety Executive suggests keeping in touch with lone workers, including those working from home, and ensuring regular contact to make sure that they are healthy and safe. If your contact with your workers is poor, then there's a risk that your workers may feel disconnected and isolated, and this can affect stress levels and mental health. There is a lot of guidance on lone working that can be of assistance to businesses to help them comply with their legal obligations. And again, this is available on the Health and Safety Executive's website for free. Stress and mental health is something which is becoming much more prevalent, and I'm seeing more and more pieces on television and in the media about this, because working from home can cause work-related stress and affect people's mental health. Being away from managers and colleagues can make it difficult to find proper support. So it is important that employers keep in touch with staff and put procedures in place so that they can recognise the signs of stress as early as possible to avoid something going wrong further down the line. Another main risk for those working remotely is working with display screen equipment. For those working at home on the longer term basis, the risks associated with using display screen equipment must be controlled and managed in accordance with the health and safety regulations, which are specific to this issue. And this includes doing home workstation assessments. So businesses need to determine when any of their employees move into the long-term home working category if a display screen assessment is necessary to avoid things like musculoskeletal injury or other health issues arising. Temporary workers don't have to be managed in the same way, but employers can still give advice to their staff to complete their own basic assessment at home. The HSE again has practical workstation checklist on its website and a video which shows people how to set up their workstation correctly to avoid causing physical issues. HSE also advocates some simple steps to reduce the risks from display screen work, which include breaking up long spells of working in front of display screen equipment, taking breaks of at least 5 minutes every hour, or changing the activity if possible. Avoiding awkward static postures by regularly changing position, getting up, moving around or doing stretching exercises, and avoiding eye fatigue by changing your focus between screen and paper, and of course remembering to keep your eyes moist by blinking often. Some people in your organisation may also have specialist DSE needs, which require a specific keyboard or a supported mouse, for example. Managing these people might mean allowing them to borrow equipment from the office and taking it home with them. For other larger items such as ergonomic chairs, height adjustable desks, you can encourage your workers to try other ways of creating a comfortable working environment, for example, support cushions. And again, HSE have guides with more information contained on this on their website. For businesses continuing to operate or transitioning back to the workplace, as is on the right-hand side of the slide there, this is very much a developing situation. In Scotland, the law and government guidance is still very clear. Unless the business is delivering an essential service under the health protection regulations, and most professional services are not essential, then employees should continue to work from home. However, in England, the UK government has confirmed that from today, the 13th of May, where a person cannot work from home, they should be actively encouraged to return to work. Returning to the office will come at some point in Scotland too, and the risks arising from that business activity will have to be managed to ensure compliance with law. And there is plenty to think about. I've listed a few bullet points at the bottom right of the slide there, and I would just like to touch on two of those, commuting and consulting. Now, if anything, the nature of this crisis has extended the health and safety duty for employers, and that duty now starts before the doors of the workplace. Employers should now, in line with their duty to risk assess, consider how their employees are going to commute to the workplace. This duty, as we discussed earlier, also covers the impact on other members of the public who are not employees. So if your staff are commuting using public transport, for example, then the English guidance says this is to be avoided wherever possible. Are they able to commute by private car, on foot, or by use of bike, for example? Employers might also consider issuing guidance to their own staff on this in line with what the government are saying. The other point that I would like to highlight there is the legal duty that an employer has to consult its workforce in relation to introducing new systems governing health and safety management or changes to any old system. This duty, I have to say, is not something that has been much of a live issue pre-COVID, but we are starting to be asked about this more and more. I think the important thing to highlight is that there is no set pro forma for this process. It is very much, if you like, consultation with a small c, but it's certainly recommended that employers record the discussions that they are having with staff or staff representatives and the feedback that they are receiving. They might even wish to consider having trade unions or staff safety representatives sign off on their new risk assessment to evidence consent and acceptance of the new procedures. If asked later what you did to discharge your legal duty as an employer, written records are the best way to cover yourself. Now, due to a lack of time, I won't go into too much detail here about the specific regulations, but if anyone does have any questions on the specifics of this topic, please do feel free to ask at the end or to contact me directly. For England, the UK government has confirmed in its plan to rebuild, which was published on the 11th of May, that employees should continue to work from home if possible. If it's not possible to work from home, then travel to work if it's open, and all workplaces should follow the COVID-19 Secure Guidelines, which have now been published. Face coverings are advised where social distancing is not possible and people are likely to come into contact with those outside of their immediate household. Now, the COVID-19 Secure Guidelines set out how each type of physical space can operate safely. There are specific guidelines for offices and contact centres, which include advice such as maintaining the 2-metre social distancing at work wherever possible, taking steps to stagger the entry and exit times, including varying shift times if necessary, keeping small teams together and contained to minimise the risk of contact with other employees, and avoiding travel and in-person meetings where possible. Encouraging workers to cycle, drive or walk rather than using public transport, and encouraging workers to wash their clothes or uniforms more often. Obviously, for sectors which include construction, surveyors, people who need to regularly travel from the office setting to sites, these types of guidelines do throw up some more questions and considerations that will have to be given than just what will happen inside the office itself, if that is part of the work activity. Interestingly, the guidance in relation to face coverings recommends that employers support, and that's a direct quote, employees who choose to wear a face covering. Now, I think that is something which, although it mirrors to an extent the advice that's been given in Scotland in relation to face coverings, it's not very clear, and we're certainly going to need some guidance or some further guidance on that as matters progress. I think just to sum up, I would highlight that this is very much a new situation for everybody, and there is no established framework as yet for operations. So it's very much back to basics. Know the law, assess the risks that your business presents to employees and others, devise a system that minimises those risks, implement the system, and enforce use of the control measures which you have selected for your business. The situation is fluid, and risk assessments will need to flex and be revised as new government guidance and science emerges over the coming weeks. And your operational activities will start to throw up new things to consider. So ongoing review will be necessary to ensure that the risks are being appropriately managed. And on that note, I'll hand back to Louise.
Thanks, Victoria. An awful lot to think about there from a health and safety perspective for office workers who maybe haven't had to apply their mind to it in as much detail previously. I could certainly feel myself straightening up in my chair as you were speaking. So in practical terms, what should practices be doing when issues arise, and whether it be issues relating to professional indemnity matters, health and safety, or any of the other problems that businesses are dealing with as a result of COVID-19? Well, there are some steps set out there on the slide. Number one, in my view, is to have someone whose job it is to deal with problems. An enviable role, one might think, but actually dealing with somebody else's problems is much easier than dealing with your own, certainly in my experience. So for professional practices, appointing a designated person to do just that is absolutely key to ensuring that there's a well-managed process there when the issue comes up. That person can usually take a bit more of an objective view than perhaps the person involved in giving the advice or doing the work. And they should act as the point of contact for dealing with any inquiries or issues. They can also take care of any necessary internal or external reporting that might be needed. And that leads us on to point two, which is that any relevant insurance policies for any of these issues that arise will spell out a duty to notify claims or circumstances giving rise to claims, and that duty will be to notify promptly. Now, this is the same whether we're dealing with professional indemnity, employers or public liability, business interruption, or any other type of insurance cover as a general rule. The specific difficulties that policyholders are facing in the current climate will not necessarily be obvious to their insurers. So if there are identified issues or risks which could lead to losses, then notifying those circumstances to brokers or insurers as soon as possible is absolutely essential to having the best chance of maintaining any relevant insurance coverage. Looking at point three then, in order to maintain the possibility of cover, it's crucial that policyholders also adhere to any of the obligations that the policy or the existence of the policy imposes on them. Now, that might not always be clear just from reading the policy documents. There could be, for example, warranties that have been given at the inception of the policy and which must be adhered to throughout the policy term. Businesses which, due to COVID-19, are perhaps diversifying or trying to pivot by undertaking other types of work must also consider updating their insurers about those changes and checking for any exclusions from their existing cover. Then finally, at point four, if an issue does arise, then consider again whether to notify insurers if you haven't already, but if there is any uncertainty at all about what to do, seeking advice or clarification can be a helpful step. So to round off, here are some ideas then for minimising some of the risks that we've discussed today, and indeed any risks to professionals or their practices, whether due to the current situation or due to any other factors. We've talked about communication, and that features, of course, in relation to not only defining the scope of work, and we talked about terms and conditions too, but also in relation to communicating internally inside your own organisation and with clients and customers. Getting ahead of any problems will be absolutely key wherever possible, so assessing and regularly reviewing risks will be important, and those are risks that relate to all of these issues. Victoria talked about it too in the health and safety context. So whether the risks relate to the type of work being undertaken, the well-being of workers, issues specific to a particular sector, or those risks that arise from the way in which we are working now and the way in which we're going to be working in the coming months. Record keeping is absolutely key, as Victoria said, and that's true again of all of the types of problems that can arise. Documenting those risk assessments and documenting the work that's being done by home workers, including any advice that's being given to clients, will be more important than ever when any issues start to materialise. So having a designated person to deal with those issues promptly can also pay dividends, as we've seen. Finally, the question of seeking advice, it can be helpful not just to make decisions, but perhaps at a later stage in order to justify decision-making processes and to improve the prospects of maintaining insurance coverage or defending the reputation of a professional or practice in the event of a complaint or claim. So that takes us to our question portion of the session, and I can see there have been a few questions popping up as we've been speaking. Just to touch on one of those to begin with, somebody has asked, surely a professional who can't meet a deadline for a client due to COVID-19 won't face a negligence claim later on? Well, yes, you would think that might be a reasonable view to take, and probably it's reasonable to expect that there will be some relaxation of the usual rules. So in the sense that professionals might have some leeway given to them by people setting deadlines, be it HMRC or I suppose public bodies, planning authorities, that type of thing, or other parties to a contract even. They might agree to extension of a deadline, for example. But there are some deadlines that simply can't be moved, usually due to law where there are statutory requirements. And unless we have some sort of emergency legislation that relaxes any of those specific requirements, then a professional failing to meet a deadline on behalf of a client will potentially face a claim, and whether or not that claim succeeds will likely boil down to whether or not the professional took reasonable care in trying to meet the deadline. The sorts of things that might be thought about is whether they can or should have done more to try and proactively manage the process, and if acting with reasonable care they should have been able to avoid the problem. And if the answer to that is that they should, then there may be a valid claim for any losses that come up. So I suppose that takes us back to the sort of best practice issues of trying to plan ahead for deadlines, take into account any issues that third-party service providers might have, or others that you are dealing with, and speaking to clients about these issues and making sure that those for whom professionals are acting are aware perhaps of some front loading needing to be done and stages needing to be brought forward with sort of earlier action, and that means perhaps costs being incurred sooner than would otherwise have been the case, but that's the world we're living in at the moment, I think. Just having a look at other questions, Victoria, I can see there's quite a lot of chat there about face coverings. It's a hot topic. You touched on it. Is there anything else you want to add to deal with any of those queries that are coming up in the Q&A?
Yeah, so I think, as everybody's sort of rightly picking up on, it's the lack of guidance. And at the moment in England, this recommendation that employers support their employees, well, the guidance does at least make clear that a face covering should not be a mask, and the government intention there, quite rightly, is so that we are not diverting critical PPE, which is in short supply just now, from frontline workers in the NHS. But there is no other detail provided, which is problematic. So What does support mean, and what does it require of an employer? Well, it's just not clear at the moment. It might mean that an employer is required to provide face coverings. Now, if that's the case and an employer does opt to provide face coverings for its staff, they are also going to have to provide guidance to the staff on how they wear the face covering, when they wear it, how regularly it's changed. It's also going to raise the question of who has responsibility for washing or disposing of the face mask, and how will the employer go about enforcing the use of the face covering. So there's a lot to think about around this issue, and I have to say the guidance is not clear, but we can but hope that there will be some more information forthcoming. But it's important to think about the wider issues that could come in if you do decide to move down a line of recommending face coverings to your staff.
Yep, and as we said, documenting that decision-making process, so that if an explanation has to be given, then there's something there to rely on.
Absolutely.
I think we've probably just got time for maybe one more question. I can see we've been asked about whether or not people really need to notify COVID-19 to insurers because insurers know all about it. Well, absolutely, of course, yes, they do know. They're all too aware, in fact, of the COVID-19 situation. But I suppose the point is they can't know about the specific issues that policyholders are facing due to the pandemic, and there's been no relaxation of what will be a contractual duty in the vast majority of cases to notify insurers of circumstances or claims in order to preserve cover. So the usual process should be followed. Of course, that's not going to be dear insurer, there is a pandemic. It will be dear insurer, there is a pandemic, and as a result I'm having these issues. And doing that will be the best possible chance of preserving insurance cover. I think we're just about to run out of time, so I'm reluctant to delve into another question at this point, but I can see we do have details for most of the questions that have been submitted. What we'll do is we will come back to those who have submitted questions and try to answer as many of those as we can during the course of today. But please don't hesitate to get in touch with us if there's anything else you would like to discuss. There are lots of interesting issues coming up for us on a daily basis. There's lots of information on our COVID-19 hub, so please do have a look there too. And thank you very much for your time today. It's been an absolute pleasure to speak to you, and I hope everybody has an enjoyable rest of their day. Thank you.